Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, it's a good thing that we have cases such as District of Columbia v. Heller, which says that, you just cannot ban all-out platforms of weapons, especially those that are in common use for lawful purposes today. That would be unconstitutional. Unfortunately, we have many state legislators around this country that have never read the Heller opinion and candidly wouldn't care if they did read it or not. And what I'm talking about is all the states that have assault weapon bans and states that are kicking that idea around, because even though there's a laundry list of states that already have them, there are several more that think that is a fantastic idea. I'm going to try to get you guys up to date on something that I get a real common question on, which is what's happening with these cases. We're going to update you on 5 separate assault weapon ban cases and pray to God that one of these actually is going to save the day. I don't know if it will or won't, but we do know one thing: the wheels of justice oftentimes turn very slow. So today, let's spend a few minutes and let's talk about, are any of these assault weapon ban cases going to save us? All right, so here's what we're talking about today. We are talking about assault weapon bans, or what we all like to call banning an entire platform of firearm known as semi-automatic rifles. Now, while there are many states who currently have these bans in place, there are several more states that are thinking about this. And despite the fact that the Heller opinion clearly holds this as unconstitutional, we are yet to have the United States Supreme Court definitively answer that. One of these, hopefully and likely, will get there and be that case. What I want to do is get you up to speed on all 5 of these cases. Where are they now? What is going on? The first case we're going to talk about is Miller v. Bonta. That is in the 9th Circuit. This is a challenge to California's assault weapon ban. This is a case in which Miller has prevailed not once, but twice at the trial court level, and once at the 3-judge panel level, has failed miserably before an en banc panel of the 9th Circuit, and has now been sucked back up by an en banc panel of the 9th Circuit. We believe the fix is in on this case, that the 9th Circuit will magically uphold California's assault weapon ban. It is set for oral arguments, however, on January 24th of this year, so that is the one which is most rapidly approaching. The briefs are in, the amicus briefs are in, we are ready to roll on that case. That is Miller v. Bonta. Now let's talk about Cockins v. Pritsker. This will be one of the 2 cases that we're going to talk out of the state of Illinois. This case has already had a petition filed to the United States Supreme Court. That petition was filed after the 7th Circuit decided, don't want to hear it anymore, it's all good. That petition was filed on December 14th of 2023. Now, this is an interesting case because in addition to all the Second Amendment issues that we would anticipate to have, this one also has a very interesting judicial ethics angle, based upon the fact that you had 2 Supreme Court justices who received more than twice the amount of money that they should have from Governor Pritsker, and then didn't recuse, and then turned out to be deciding votes, and, well, hey, only in the state of Illinois. That case is Cockins v. Pritsker, and right now, I would say that that case has probably got the inside track to be the one to get to the United States Supreme Court. Once again, petition for certiorari filed December 14th, 2023. Then there's another case out of Illinois called Bevis v. Naperville. We've talked about that case. We've talked to Rob Bevis. Now, this one doesn't necessarily have the same angle as Cockins v. Pritsker does, because it's got 2 separate angles there. It has one, the judicial ethics issue, and then it also has the firearms registration component, which is, the fact that we're talking about that in the year 2024 is amazing. Bevis v. Naperville was also shot down by the 7th Circuit. Now, they have not filed their petition yet. I had an opportunity to talk to one of the very interested parties in that case. We believe that a petition on behalf of Bevis and all the other named plaintiffs will be filed in early February to the United States Supreme Court. Certainly, the United States Supreme Court could accept that Cockins and the Bevis case and consolidate it, so that would give both of those cases the inside track. Okay, then a case that we just talked about is a case of Bianchi v. Brown. This is a challenge to Maryland's assault weapon ban. It was originally called Bianchi v. Frosch. Now, it was GVR'd all the way back down to the Fourth Circuit in like August of 2022. And now here we are in January of 2024. Oh my God, they're going to finally set argument for an en banc hearing that's going to be the week of March 19th through the 22nd before a full en banc panel of the Fourth Circuit. God only knows when they'll get around to actually issuing a ruling. That case, once again, is Bianchi v. Brown. And then finally, on the Washington level here, there's the case that challenged to House Bill 1240, now codified in the RCWs. Washington's assault weapon ban. That case is the case of Guardian Arms v. Insley. That case was originally filed in Grant County, then removed from Grant County to Thurston County. Never a good thing. An injunction was denied, and that ruling is now on appeal before the Washington State Supreme Court. They could easily kick it back down to Division II Court of Appeals. Essentially, that case is stuck in litigation purgatory, exactly where the Washington State Attorney General wants it. On a side note, and this is important, I want everyone to be aware of this, is I have been accused of being incredibly critical of the NRA. And the reason I am accused of that is because I am, in fact, very critical of the NRA. And I will let the record speak for itself. However, we try to keep things down the middle here at Washington Gun Law. And when people do something right or they deserve an attaboy, we're going to give them an attaboy. And I want you to know that the NRA has kicked in $75,000 to help the silent majority in the case of Guardian Arms v. Insley. So I know I'm kicking them in the teeth all the time, but hey, they have stepped up big time here. $75,000 to help that cause from the NRA to the plaintiff's attorneys there in Guardian Arms v. Insley. So kudos and thank you very much to the NRA for that. So that is your up-to-the-minute update on where we sit with all of the various assault weapon ban cases kicking around in various jurisdictions throughout the country. For states like New Mexico and Virginia and Colorado and some of the other states that are kicking this idea around, you may be joining this club soon where you're going to be much more interested in these cases as well until we can finally just get our big coup de grace before the United States Supreme Court. Listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. Now, in the meantime, let's everybody remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.